Hi everyone, welcome back to Let's Talk Legal with Karimi Chege. My name is Ashley Karimi Chege, an advocate of the High Court of Kenya and your go-to employment expert. This is Season 1, Episode 6 of Employment Law Unlocked, where we'll be talking about annual leave. So what are the objectives of today's episode? One is to expound on the law that provides for annual leave as a statutory entitlement. Under this, we will be talking about A, how many days of annual leave is granted to an employee per year. B, how is annual leave days calculated? C, can annual leave days be carried forward or forfeited? And D, who bears the obligation of keeping records of utilization of annual leave days? So let's get straight into the episode. In regards to the law that provides for annual leave, Section 28 of the Employment Act provides that an employee is entitled to a minimum number of 21 annual leave days per year with full pay. In regards to these days, they are considered working days and not calendar days. That means the 21 annual leave days are excluding public holidays and weekends. Also, the law envisions these 21 annual leave days as the minimum number of leave days that can be granted to an employee. This means that this is the base and not the ceiling, and nothing stops an employer from providing even more annual leave days to his or her employee if they so wish. In regards to calculation of annual leave days, the law provides that the same is calculated as 1.75 days per month. If you were to do the math of 1.75 times 12 months, which is what amounts to a year, you will find that the same amounts to 21 days. So, how can an employee utilize their annual leave days? The law gives the employee two options: either to utilize the entire 21 days as a lump sum, or with the consent of his or her employee, they can decide to split up the annual leave days within the leave earning year. The law has no problem with the employee who decides to split their annual leave days within the leave earning year. However, the problem comes in when an employee is not able to fully utilize the split annual leave days within the leave earning year, meaning there are unutilized leave days that are to be carried forward to the next year. The law provides that if you have split your annual leave days and some leave days are being carried forward to the next year, you as an employee are entitled to ensure that within the leave earning year, you have utilized a consecutive period of 2 working weeks of your annual leave in the leave earning year, and then the remainder of your annual leave days, you utilize them within a period of 18 months from the leave earning period. I'll give an example. So if you're working with the year 2019, you should ensure that you utilize a consecutive period of 2 working weeks of leave days within 2019, and the remainder of your annual leave days that you're carrying forward to 2020 should be utilized within 18 months from 2019. The law does not provide for what happens in the event that you do not utilize the remainder of your annual leave days within the 18 months provided. And this gap in the law is what has led to the confusion in regards to whether annual leave days can be carried forward or forfeited. As it stands, the law does not talk about forfeiture of annual leave days. It only provides for unutilized leave days that are being carried forward to be utilized within 18 months. However, noting that there is a gap in the law as to what happens if the same are not utilized within 18 months, some courts of law have inferred that unutilized leave days can be forfeited. However, I would like to reiterate that there is nowhere in law that supports the forfeiture of annual leave days. And we'll see that in the case summary. What happens in the event of termination? The law provides that in the event of termination, where an employee has worked for his or her employer for a period of more than 2 months, that employee is entitled to annual leave pay. The same should be calculated as per what we have indicated, 1.75 days of annual leave per month. This is to be calculated with the full pay of the employee in mind. Now let us talk about who bears the obligation of keeping records of the utilization of annual leave. The law provides under Section 74 of the Employment Act that the employer is the one who bears the burden of ensuring they have records of the utilization of annual leave days of their employees, how many days have they utilized, and how many days are accruing to the employee. Therefore, in the event that the employee goes to court and challenges the employer for accrued leave days, the law puts an obligation on the employer, to prove how many days the employee has actually gone on leave and how many days pending for them. Now let us talk about the case of Milka Kulati versus Music Copyright Society Limited 2014. In this case, Milka was employed in 2012 as the management accountant by the employer and rose the ranks to the position of Chief Executive Officer in 2019. In 2021, Milka was unfairly terminated and filed a case in court seeking a couple of things, including accrued leave pay arising from accrued annual leave days from the year 2017 to 2020. In support of her case, Milka had produced a payslip from March 2019, which indicated that she had accrued leave days amounting to 136.50 days. However, the respondent's argument was, under Clause 10 of the employment contract between Milka and itself, and Clause 5.5 of the Human Resource Manual, it stated that if an employee does not utilize their annual leave days within the leave earning period, such annual leave days stand forfeited unless the employer's board sanctions the carrying forward of such leave days. So the court was faced with the question of establishing whether Milka was entitled to accrued annual leave pay. The court noted that under Section 28 of the Employment Act, annual leave is established as a statutory entitlement, which under the Employment Act is indicated as a minimum term and condition that cannot be done away with by contract. The court also noted that general forfeiture of annual leave days is unlawful and has not been contemplated by law under the Employment Act, and indicated that the only instance where forfeiture of annual leave days is viable is where the employee has split up their annual leave days and has utilized a portion of the annual leave days within the leave earning period, and the other portion has remained unutilized. The court therefore noted that it was not possible for an employer to do away with a statutory entitlement enshrined by law through contract. In support of this, the law relied on the case of Rumba versus Southern Hills Development Agency, where the court indicated that the Employment Act does not envision forfeiture of leave days, and Unutilized leave days should therefore not be forfeited. The court insisted that accrued leave is a benefit to the employee and should be monetized and paid off to the employee at the request and demand of the employee. In light of the above, the court found that Milka had made a case for her accrued annual leave pay and proceeded to grant her the sum of 1,477,216 as accrued leave pay for the year 2017 to 2020. So what can we learn from this case? 1. Annual leave is a statutory entitlement that cannot be done away with by contracts signed by parties. General forfeiture of unutilized annual leave days is illegal. We have also talked about the glaring gap in law in regards to splitting of annual leave days where there is a spillover to the next year. Remember, the law provides that the remainder of the annual leave days should be utilized within 18 months from the leave earning year. However, I would like to reiterate that the law does not provide for forfeiture of annual leave days anywhere under Section 28 of the Employment Act. However, the gap that has been left in regards to that provision of law is what is leading to the varying interpretations by courts of law as to whether forfeiture of annual leave days, if they are not utilized within 18 months from the leave earning year, is legal or not. My take would be forfeiture of annual leave days is illegal. The law is silent on forfeiture of annual leave days and therefore it cannot be inferred from the law. That marks the end of episode 6 of Employment Law Unlocked. But stick around for episode 7 where we continue to talk about the benefits under the Employment Act. You do not want to miss this. Thank you so much for watching and see you on the next one. Remember, information is power, legal knowledge is freedom.